How's the lighting? Hi, this is Rick Roller, and tonight we're going to be talking about contract law. This is your chance to pass the exam the first time. We hold these little Google Hangouts in order to get you through the real estate exam the first time. I already said that. Well, but I said it twice because I don't want you to take the exam twice. So tonight we're going to talk a little bit about contract law, and after contract law, I'm going to do some questions that have been sent in. And if you'd like to send in a question, please leave your comment on the YouTube channel. You can leave a comment after the video, or if you'd like, you could also put your questions. There's a mechanism to get to us through Google Plus as well. So two different ways that you can send in questions, and we'll get them answered. We've got a number of questions that I'm excited about talking about tonight. And also, we're going to also cover some practical aspects of real estate and getting going into business after you pass the exam, like what am I going to do next? Okay, so contract law is a critical part of your real estate exam. There are so many different terms you have to know, and as you well know in real estate, through the whole course that you're taking at whatever school you happen to be going to, you need to know that there's about 400 words that you're going to have to get a handle on. And there's just no way around it. And if English is your second language, it's even going to be more difficult for you, because devious exam writers will take these words and they will write questions that, boy, there's this answer A or B sure sounds good, but the right answer is down a little bit lower. I'll give you some examples of that in just a minute. Okay, now when you're talking about contracts, there's some of these terms that pop up a lot, and you'll see this in any school's curriculum, is unilateral and bilateral. Uni means one, bi means two. And so a unilateral contract is where there is a promise only made one way. One way. Uni means one. So the best example of a unilateral contract is an option agreement. Because an option agreement, there's only a promise being made from the seller to the buyer. The seller says, yes, if you want to buy at this price and this term during this period of time, I will sell to you if you decide you want to buy. So the seller is obligated, but the buyer doesn't have to buy, they have an option. And that's why it's only a one-way promise or a unilateral promise. So, just tie unilateral with an option agreement as the best example, because that's probably what you're going to see. Bilateral contract, probably the best example is the buy-sell agreement. And in many states, they have different names for that, but the buy-sell agreement is the contract between the seller, obviously, and the buyer. Buyer promises to buy, seller promises to sell. Okay? So let's get a little bit more comfortable here, and let's talk about some more terms that are also important. And contracts can appear in a number of different ways. Another term you see quite often on the exam is the word express. And when you see the word express, it means done with words. So an express agreement is one that is done with words. It wasn't done by innuendo or intention or in any other manner other than the fact that it was put together by words. Now, the words could be oral or written, and we'll talk a little bit later on why real estate contracts, being so important, have to be written. But that's important too. And then there's other E words that you're going to see on the real estate exam as well. For example, to execute a contract. To execute a contract is to sign it. And there's also a term called executory contract. An executory contract is one that has been entered into. It meets the test of being a valid contract, but it hasn't been finished yet. And then there's an executed contract, one that was put up against the wall and shot, meaning it's over with, it's done. So these are some of the terms you might see as well. I would rate the probability right up there about 85%, and so you've got to learn your terms, folks. There's a lot of different tools you can get. We have a whole package of stuff that, that are very, very helpful, that has all different kinds of methods of teaching you the vocabulary. But whatever method you try to use, you need to get those words in your head, because you're going to see them again and again. And it's and like I said earlier, it's particularly hard for people where English is your second language. Okay, let's talk about the essential elements of a contract. Very, very important. The essential elements of a contract are things that must be there in order to have a contract that is between, like a buyer and a seller. Or perhaps if it's a unilateral contract, of course, we talked about the option. If it's a bilateral contract, it's probably the buy-sell agreement, which I mentioned had many names. And there are 4 essential elements. The first one is mutual agreement. And mutual agreement is where you have a meeting of their minds. Everyone understands what they're getting into. There's no confusion. There's no hidden agenda. There's no situation where someone is trying to deceive someone. It had an offer, and then the offer was complete, and it was clear in its terms, and it was accepted during the time limit. Now, in real estate, when buyers are usually the ones that make the offers, I had a situation one time where we had a buyer kept coming back and looking at the property and looking at the property and looking at the property, and it was driving the seller crazy. And he kept saying, well, why don't they just make an offer? I mean, they've been here like a dozen times. They're driving me crazy. And of course, then the seller was driving me crazy. And I said, well, let's just make them an offer. And so I just sat down and wrote an offer for the buyer from the seller, and I called the other agent and said, look, your buyer's driving us crazy, so my seller said, here's what I'll do. Here's an offer. And so the buyer looked at it and signed it, and that's weird. It doesn't happen that way often. What happens is a buyer makes an offer, and the offer is clear and complete, and the seller looks it over and says, yeah, I'll go with that, and they accept it. And most offers have a termination deadline, or they lapse. And if it was accepted after it lapsed, after the deadline, then it's not a valid contract. Now, you could amend the deadline, and there's ways to work around that, but that's the offer. Now, offer must be clear and complete. Now, the other thing that you'll see quite often, and that really ticks people off, is that an offer can be withdrawn any time prior to being accepted. So you have 2 things that can kill an offer. One, of course, it can lapse. The deadline expired, it's done. Or the buyer can get cold feet and withdraw it. Maybe they found something else they like better. Maybe their transfer fell through, or maybe they got to considering the fact that, gosh, it didn't have the 3-car garage, and we thought, well, maybe we can live with 2 again, but after we thought about it overnight, we just don't want to do it anymore. And if the contract has not been accepted, it can be withdrawn, and that can make a lot of people upset. So you've got to be careful when you're presenting things to a seller that they know, well, we want to think it over. We want to sleep on it. Well, that's fine, Mr. Mill. That's certainly within your prerogative, and I wouldn't want to push you into anything. But please understand that we must accept this offer prior to its lapsing. And the second thing I want you to understand is that the buyer can withdraw the offer any time prior to your acceptance. So, and that works the same way with the counteroffer. When the seller receives that offer, they don't have to accept it. They could say, well, we won't do that, but we will do this, and they counter. And then that counteroffer can be withdrawn by the seller. And this we see more often. Where a buyer's made an offer to a seller, the seller makes a counter to the buyer. And in that thinking about it period, before that counter actually lapsed, but before the buyer has accepted it, another offer comes in that the seller likes better. It's even better than their counter. And so they withdraw the counter and accept the other offer. And that tends to make people makes a lot of heartburn for agents as well. But that's the seller's right. The seller has the right to withdraw. The buyer has the right to withdraw anytime before that offer is accepted. And we'll talk about acceptance in just a minute. But if they reject the offer, if they say, I don't want to do that, then, of course, that offer is dead. But sometimes the seller will reject an offer and then come back later and say, well, I've been thinking about it. Maybe I should have taken that offer. And it's too late then. They already rejected it. But you could call the other agent and say, would that buyer be willing to make that offer again? Yeah, maybe they would. Okay, then you have an offer, and then you have to have an acceptance. An acceptance must be clear and complete, and it must be communicated to the other party or the other party's agent in most states. And so what happens is, if the seller has signed it and it's accepted, and you tell the other agent, in most states, then it becomes a binding contract. In some states, you need to check your state law. Then what happens is that acceptance has to go all the way back to the buyer who made the original offer. And so you call them up, and you tell them. And a lot of agents have funny stories about stuff like that. I heard a story one time that the agent went to call their buyer after being called by the listing agent and said, well, okay, the seller accepted your offer, and say, oh, great, I'll call the buyers. They're at the hotel. So he called, and the switchboard operator put him through to the wrong room. So the guy picks up the phone, and man, he wanted to make sure that offer was accepted and that no one would say anything about, well, I changed my mind. I'm withdrawing it, and you didn't tell me it was accepted before I withdrew it. And so as soon as that person answers the phone, he says, hey, congratulations, your offer was accepted. And the person on the other end of the line said, what are you talking about? I didn't make any offer. Well, isn't this the Harrisons? Oh, no. This is the Smiths. You got the wrong room. Oh, well, sorry, but now that I got you on the phone, do you want to buy any real estate? Did a little prospecting as well there. But we used to do things like that in order to make sure that people felt like they were obligated and bound. But a lot of states have tweaked their state laws so that if that other agent is truly representing the buyer, and then he can accept the communication that the offer was accepted. And some states have escrows and other facilities that take care of some of the stuff as well. But you need to find out what your state does. But for the real estate exam, the national portion, the offers must be clear and complete, and they must also be what we call prima facie. Now, prima facie means they stand on their own, so that if the seller accepted it, then it would become a binding contract. If that offer was written so sloppily that in one section of the offer it said, I will pay this amount, but then in another section of the offer it says, I'm paying this amount. So there's contradictions. It's not prima facie. It's not really a valid offer, because a valid offer would be clear and complete. But at least it's someone that's interested in the house, and maybe they just had an agent that was a little less experienced and wrote it up in a very sloppy, unprofessional manner. You can still work with that. You got to straighten it all out with a counter proposal, but at least you have a buyer that's interested in the house. Okay, so mutual agreement, there must be a meeting of the minds. There can be no mistake. If you thought you were buying the pink house on the corner, but you were really wrote up an offer on the blue house in the middle of the block, then obviously you didn't have mutual agreement. Okay? Consideration. Consideration is the second essential element of a contract. And consideration can come in two flavors. It can be good or it can be valuable. Good consideration is love and affection, loyalty, that type of thing. Valuable consideration you can count, including promises for service, because you can put a monetary value for those promises for service. So valuable consideration has money. And now consideration on an offer is not necessarily the earnest money. You can have zero earnest money, and still, the promise to buy could be considered enough consideration to have a valid binding contract. And sometimes, you'll see agents that will say, well, no, you have to define consideration by having at least some valuable consideration. And that's not true. What they're thinking about is a deed. And when a title company or an escrow officer or a lawyer prepares a deed, many times they'll write on there $10 and other good and valuable consideration, because they don't want to put the exact amount of valuable consideration in the contract, just because they don't want anyone to know. And if you're in a non-disclosure state, like the state that I live in, Utah is a non-disclosure state, it makes it very difficult to figure out, what properties are going for. Many states have other ways of handling that, like Colorado has a documentary fee, And a lot of states have that, where there's a formula, that if the house sold for $410,000, they paid a $41 dock fee. And so if you know the formula, then you know that they sold for $410,000. But Utah doesn't have a dock fee, and it's a non-disclosure state. People have to have another essential element in order to do contracts, and that is capacity. You must be of legal age, and you must be of sound body and mind in order to enter into this contract. Now, when I say body and mind, I'm really saying more mind than body, but nevertheless, you have to be able to enter into a contract. If you are of sound body, but yet a judge has ruled that you lack capacity because you're crazy, or you have serious dementia, or you have other types of problems, then you can't enter into a contract. Minors can't enter into a contract, as I already mentioned. But there's a lot of tricks in the exam. I mean, just because you're physically challenged, like you're blind, or if you don't speak English, but you're buying a property and you're using an English document, that doesn't necessarily mean you lack capacity. And you will see that on the exam a lot. So lacking capacity means you're not a lawful age, or you have been adjudicated incapable. And that's what that means. And then the last one is legal purpose. I mean, buying and selling real estate is a legal purpose. But the old mafia term to put out a hit or a contract on someone, murdering someone, is not a lawful purpose. So therefore, can't do that. Of course, you'll be just as dead, but it's against the law. You cannot do that. It must have a lawful purpose. So those are the four essential elements: mutual agreement, consideration, capacity, and a lawful purpose or legal purpose. Okay? Now, for real estate contracts, sometimes we say there's a fifth, and the fifth is because of the statute of frauds. And the statute of frauds is one of those uniform statutes that have been enacted in virtually all states. And the uniform statute says that there are certain types of contracts that are so important that they must be in writing in order to be enforceable in a court of law. So you can have a valid contract that's verbal, and the statute of fraud says if it's for something under $500, then it is binding, but that's not much real estate, right? I mean, you're not going to find much for $500 or under, obviously. So real estate's more than that, and so it must be in writing in order to be enforceable. But you could be out looking for a used barbecue, and you find one for $100, and you say, well, let me go to the ATM and get the money, and you shake hands on it, and you run to get the money, come back, and you sold it to somebody else. You had a binding contract. So, you could go to court over that barbecue, which would be a little stupid, but, you could. But you don't want to do that. But real estate is so important, so valuable, and dealing with so much larger amounts of money, in order to prevent fraud, in order to prevent misunderstanding, we have the statute of frauds, which is a state law enacted in most states, that says that in order to be enforceable in a court of law, it must be in writing. Do not depend on verbal contracts, however, because most states, in their rules and regulations, have prohibitions against real estate agents doing contracts that are not written. A buyer or seller on a for sale by own, or on a sell by owner, you can get together and shake hands, and they may even get to a closing. But even if they go to an escrow company or a lawyer to sort all this mess out, the lawyer or the escrow company is probably going to insist that they put together some sort of written agreement, just because it just makes sense. Okay, different terms about contract. You can have a valid contract. In order to have a valid contract, a contract has to have those four essential elements. But what if you have a situation where there's partial missing one of those four essential elements? It's just not exactly all there. For example, you have an adult seller, but you have a minor buyer. Some minors have done very well. Some minors you have heard about maybe have become stock market aficionados and made a lot of money. Their dad or mom set up, or both, set up a trading account for them, and they've just been trading online, and they made tons of dough, even though they're not 18 or older. And you've also heard about minors that have done really crazy and wonderful things on the internet by designing a game or playing games or making fabulous amounts of dough, and they're not even 18 yet. So here's a minor that has the money. He certainly has the ability to buy this condo. I mean, after all, it's only $300,000. He's just going to pay cash for it. Enters into a contract with the seller. Now, wait a minute. Is that contract valid? And the answer is no, it's not valid because one of the parties lacked capacity. What it is something called voidable. If you have a situation where you have one party that has capacity, it could be enforced against that person. In other words, the adult can't get out of it later when he finds out that, man, this kid, I can't believe it. My condo is worth $350, and he talked me into selling it to him for $300,000. And and I signed that agreement. But I found out he's a minor. I can get out of that deal because he's a minor. No, the adult, it is enforceable against the adult. But the minor could get out of the contract. He could come in at the last minute and say, "Yeah, I changed my mind. Tough noogies, I'm walking. And by the way, give me back my earnest money." And, it's going to be a nasty battle, but the minor, it can't be enforced against the minor. And there's other issues, about putting properties in minor's name. Not necessarily. It's not necessarily a problem getting it into the minor's name. It's a horrible problem trying to get it out, unless you set somebody up in the deed who is an adult to act on behalf of the minor. And so, there's different things you have to look at there. And I know it's weird, but sometimes it's the weird exclusions that you're going to see on the test. So, is a contract between an adult and a minor valid? No. But it's not void either. It is voidable. And voidable by whom? By the minor. Sometimes you find situations where you had a valid contract, but it became voidable. Okay? Like in consideration. What if you had a contract on a house and everything was great, but you're going for the closing and the house burns down, or a substantial part of the property burns down? Enough so that, as defined by contract, the seller cannot deliver the same value that they contracted to deliver. I mean, the house is half burnt down or something. So what we're looking at there is a situation where it was valid, but because of the evaporation or some of the consideration or all of the consideration going up in smoke, it now has become voidable. Voidable by who? The harmed party. And that can happen as well. Okay, so valid, void, and voidable, important terms you need to know. Kind of fun. And of course, we talked about enforceability. Because of the statute of frauds, if it wasn't written, it would be unenforceable as well. Okay, we're not going to talk about some of this other stuff. It's important, but not that important. I do want to talk a little bit about fraud, because there's different types of fraud. There is intentional fraud, where a person had a property, they knew it was defective in a lot of different ways. Perhaps it was a radioactive dump site, and they're trying to, or more commonly, it was in an area that was near a gas station where the tanks leaked, and now that leakage has come down and it's seeped into this property. And they know it's there. They know that this property is going to require $250,000 worth of cleanup, but yet they lie about it. Now, if someone lies about something like that and said, "Oh no, this property is great, no problem," and they know there's a defect and the defect is substantial, then that is intentional fraud. I mean, there's it could be positive, where they deliberately misrepresented. It could be passive, where, well, they never asked, so I never told them, but yet it should have been revealed. And there's going to be kind of a judgment standard that a judge is going to look at there and say, well, a reasonable person should have done this. And it's not, it's not going to go well. That could end up in a criminal court. But then there's another type of fraud called constructive fraud, where there was no evil intent. You or the seller or the buyer just did a real stupid thing and didn't put it together very well. Particularly constructive fraud can fall back on agents, where they wrote contracts that were defective. And unfortunately the seller or the buyer is going to take the pain on that, but they're not going to not want to share that with the agent who actually screwed the deal up. And so even though there was no evil intent to try to cheat or take advantage of someone, that a person was still harmed. Now, either one of those, definitely on intentional fraud, but even on constructive fraud, someone could lose their license over that quite quickly. The difference is because there was no evil intent, probably there won't be any jail time, but you're not going to have a license either. And then there's a term called puffing. Puffing is a wild-eyed, exaggerated, stupid statement, kind of off the wall, kind of like, you're looking at the view out of one of the windows in the home and you say, this is the most incredible view of any home in the entire world. I mean, there is no better view at all. Or this kitchen was made for you. I mean, it's wonderful. They're not lying, but on the other hand, they're not probably very good salesmanship either. It's puffing. It's ridiculous, wild-eyed statements that any rational person would know couldn't possibly be true. Like there's no other home, and okay, I have to admit I puffed once. And unlike one of our former presidents, I deeply inhaled. Okay, now what I mean by that is, look, okay, I started in 1977. In 77, there was still a lot of hangovers from the 60s, okay? And I was working with this couple. They had the VW van with the flowers painted all over it. I mean, he had bell-bottom jeans and tie-dye T-shirt. and there was only one house in town that would work for this person. Only one. And we were standing out in front of it. And look, I was Rookie Rick. I really needed the sale. And I looked at them. We looked at the house. I looked at them. And I couldn't get any response out of these guys. So I puffed. I said, hey, look, it's smiling at you. And the guy looked at the house, and I'm telling you the truth, he said, far out, wow, and bought it. And, I related this story like, 10 or 15 years later in a real estate class. And some kind student came up during the break, and he said, Roller, you're a little naive, aren't you? And I says, well, yeah, yeah, but what? He says, well, that guy, that hippie you sold the house to, says, yeah. He says, he had been puffing before you picked him up. I said, what do you mean? He says, he was stoned, Roller. That's why you couldn't get any response out of him. And so, anyway, that's not the kind of puffing I'm talking about, even if you live in Colorado. So don't do that. But puffing won't get you revoked, and puffing won't get you in jail, but it's probably not the best sales. But I wasn't worried about him coming back to me and saying, well, I'm going to sue you because when I rethought about it, the house wasn't smiling at all; it was frowning. So, and I wasn't worried about that. Okay, ways to terminate a contract. There's a lot of different ways. The very best is performance. I mean, if you have a listing contract with the seller to sell their home and a buyer is procured, an offer is entered into, it goes into escrow, it closes out, okay? But wait a minute. You still got 4 more months on that listing contract. Maybe it was a 6-month agreement and you got it listed and sold within 2 months, and so you got 4 months of listing with the new guy, right? No, because your listing contract was terminated by performance. And performance is the best way because, seller gets their house sold, buyer gets the house they wanted to buy, and you get your commission, so that's a good thing. But it can also be canceled out or released by mutual agreement. Today, lots of contracts have contingency clauses in them, so if it doesn't check out on the due diligence period, maybe the buyer can walk away, cancel that contract. That would be a unilateral cancellation because maybe the seller still wanted the buyer to buy. But what if the buyer went back to the seller and said, look, I really don't have any good reason to get out of this thing, but heck, you don't want to sell me a house if I don't really want to buy it. Well, okay, we'll let you go, And so you come together and you make some sort of mutual. That would be a way to get out of it. Another way would be the impossibility of performance, where maybe the house burned down. Okay, so that's kind of a whirlwind tour of the important elements of a contract. I want you to go to your classes, of course, and I want you to study hard, and I want you to work on all the different terms, because there's a little bit more to it, but those are the things that I really wanted to emphasize tonight. Okay, and so I have a few questions that have been sent in, and when you send in your questions, I can answer questions about anything. It doesn't have to be tonight's topic. For example, here's one from Tim. We've had Tim send in questions before, so thank you, Tim, for sending in another one. Tim wants to know, do eviction laws vary quite a bit from state to state? And yes, they do. And kudos to you, Tim, for realizing that there are many things involved with real estate that are regulated by state law, not federal law. In fact, most things involving real estate are regulated by state law. In unlawful detainer action, which is the action that would actually create an eviction, is definitely a state law. In fact, some cities and counties have regulations and ordinances as well. So check the jurisdiction that you're living in and see what that is. But I know that the time periods vary quite a bit from one state to another. And some states, like I lived for a number of years in Bismarck, North Dakota, in Bismarck, there were ordinances against evicting someone during the winter months, because in North Dakota, if you're put out of your domicile, you could actually die, in quick order, when it's 40 below and the winds are blowing, and it's even colder than that. So it kind of depends on the jurisdiction that you're in, and the best way to learn that, of course, is to pay attention to state law. And if you are in a situation where you need to do an eviction, as an experienced real estate property owner or manager, sometimes that can be handled on that level, but quite often it makes sense to engage a licensed attorney, to help you with the eviction proceedings, because a lot of times they'll know some of the tricks of the trade. In some states, you can post a bond and do a bond eviction, where so the landlord is very upset and wants the tenant out, usually because they haven't paid the rent, or maybe they're tearing it up or whatever. But one of the quicker ways to get people out is with the bond eviction, where the landlord will post a bond, and usually the attorney they're using has a insurance bond that they use, and so they put that up, and it could be a certain amount of money, $5,000, $10,000, $20,000, whatever, and then the tenant then would either have to match that bond, or they'll have to get out, in a much quicker period of time. Now, states that have that little quirk in the law, you can get people on the street in 2 to 3 weeks. States that don't allow that and have the normal eviction process, it can vary quite a bit. And you hear horror stories about it took me 6 months to get somebody out. In some states, like California, for example, eviction is a much more labored process. In fact, there have been whole movies like Pacific Heights that have been written around trying to get rid of a bad tenant, and that you have to really understand and take that into consideration when you're being a landlord in the various states. And I don't care how careful you are, occasionally you're going to get into a situation, if you own enough properties and you've been a landlord long enough, where Tim, unlawful detainer sometimes becomes the only source there. And you're always better off if you can talk them out of the property, and sometimes you can't. I had a fourplex one time, and that I owned in Colorado, and it was a brand new unit. I developed the property and I built the fourplex there on it, and I think it was the second or third tenant in there, and he was overhauling his V8 engine in the living room, which one of the other tenants tipped me off on that, but that wasn't a very kind thing to do. But anyway, I talked him into leaving. He said it was too cold outside to work outside, and I could understand that. But if he had talked to me, I could have probably put him in a warehouse building I owned or whatever to do his car. But I had to obviously replace the carpet in the subfloor. It was quite the mess. And he didn't want to leave, but he did after we talked to him. And I introduced him to some of my associates, Bruno and Tito. Okay, I can't hear anyone laughing, so I guess that wasn't that funny. But anyway, that was a true story, except for the last part about my associates. Okay, Katie writes in. He says, "Could you give me an example of incurable depreciation? Aren't most problems curable?" Okay, this is relating back to appraisal class, and there's a term in appraisal called depreciation. Depreciation has certain things it could be, and one of them is physical deterioration. And yes, Katie, you can throw money at almost anything and fix it, even if the back half of the house was falling down. You could tear it down and replace it and rebuild it and whatnot. But what makes it incurable or not incurable is not the extent of the remodeling or repairs or fixing the damage, but what makes it incurable is, do you violate the principle of contribution? The principle of contribution says that if you put money into a property and it doesn't raise the market value to the same amount of money or more that you put into it, then you're violating the principle of contribution, and therefore it makes it incurable. That's what makes it incurable. And so if you had 20,000 repairs, but yet the property went up 30,000 or even $20,000 in value, well, it would be curable. But if you had 20,000 repairs and only pushed the value of the property up 5,000, then it would be considered incurable. And incurable could be physical deterioration, but a lot of times it's something called functional obsolescence as well, which is just poor floor plan. And to fix that, well, we got to tear down a wall or put up another wall or change something. And if you can't do that, then obviously it's incurable. Oh, okay. Sam writes in. He says, how does a non-disturbance clause work in a lease, and do most leases have them? And a non-disturbance clause, Sam, is a clause in a commercial lease. And people that move into certain types of properties and put a lot of specialization or remodeling into that property, or it just costs a lot of money to move in there. For some tenants, just setting up their phone systems and moving all their cubes in and moving all their other stuff is as many tens of thousands of dollars to move into that space. Or you put in a restaurant, you put $50,000 into your kitchen, or remodeling this property, for your themed restaurant. For that particular tenant, it becomes very, very important to have a non-disturbance clause in their lease. And the way that works is non-disturbance clause must be agreed to by the landlord and the bank, the landlord's bank. Because what a non-disturbance clause does is a non-disturbance clause actually prevents, in a foreclosure, the new owner from evicting that current tenant. He has to honor the current lease. And this is a very interesting issue, because if the property had been sold to a new landlord, the new landlord would have to honor that lease. But if the property was foreclosed on, where the lender was first in position and the lease came after, then the foreclosure wipes out all junior liens and encumbrances, including that lease, unless the bank has agreed to a non-disturbance clause. And you never see them in residential leases, only in commercial leases. Okay, can we pause for a second? Hang on, I'll be right back. Sorry about that. I had a great visual on a non-disturbance clause and thought I could pull that out of my briefcase, but it's not in there, so I'm sorry about that. But this does bring up another topic, and that is, and I've shared this before, particularly when Katie is asked questions about, do you ever get bored in real estate and that type of thing, and man, I wish I could have found that visual. I'll show it on a different program. But commercial leasing is a really cool thing to get involved with. If you have any inkling on wanting to go that direction and get into commercial real estate, a very good place to start is in commercial leasing, because it's something that could easily be broken into by someone with less experience. Now, if you have the chutzpah and you have the contracts, and or you can get the contracts because you have the contacts, and you can list multi-million-dollar properties for sale, or that's a great place to start just because you have the contacts. But if you don't know people that own $50 million buildings, or groups of people that own $50 million buildings, and you can't get the contract to sell those buildings, one great place to start is in commercial leasing, because tenants are easy to find, and you can go out and find tenants and then get tenant representation contracts signed, and then take those representation contracts and work those and get paid very well. I know that there's a lot of folks that don't understand how you get paid on commercial leasing, but I've done commercial leasing several different times in my career exclusively. There's one stretch I did it for like 6 years exclusively. That's all I did. And I worked primarily large office buildings, and it was a lot of fun, and you could make really good money. Let me give you an example. Usually if you put together a lease on a building, and let's say they're paying $100,000 in rent for 1 year, and so it's a 3-year contract, that's a $300,000 lease. Sometimes you put little annual bumps in it, so it actually works out a little bit more. Maybe it's $100,000 the first year, and maybe 110 or 105 the second year, and so you can add that up. But let's just keep the math easy. If it's a 3-year lease that has a total value of $100,000, there's going to be a 3% commission. 3% of $300,000 is how much money, folks? If it was, well, I don't know, Roller, if it was 10%, it would be $30,000, but it's not. It's 3%, so it's $9,000, right? So that's a nice little hit, and so maybe you have a split with your broker, maybe 60-40, 50-50, 90-10, whatever it might be. But that's a nice commission. It's like selling a $300,000 house. Obviously, if the rents were $30,000 a month, or $360,000 a year on a 3-year lease for a much larger tenant, then the leasing commissions become very meaningful. Now, understand that the big fish, the large tenants that take 2 or 3 floors in a building, are often chased by the agents that have years of experience and lots of contacts, and like anything else, if you are trying to list a $3 million home or a $10 million home, there are very sophisticated agents that are also bucking for that. But in leasing commercial real estate, often the medium-sized tenants, like the $100,000 a year and below, are not pursued as hotly as the big tenants. And so it's a great place to break into commercial real estate. And what you'll also find is, in trying to find tenants to move from one building to another, you can also find folks that are thinking about, well, I'm tired of renting, I want to buy a building. And so you can sell them the smaller 3 or 4 or maybe $10 million or $15 million buildings. And you can develop those relationships and make it happen. You can make a very good living quickly doing commercial leasing. And I've enjoyed it over the years, and I've worked on some very large buildings and been able to fill up 30-40% of those buildings. There's a technique involved in there's not a lot of information on doing commercial leasing, but there's probably more now than there has ever been, and there's a lot of good stuff on the internet. And we probably ought to put some information together on that and comp it out to people that are interested in doing that. I'll tell you what, if you're interested in doing commercial leasing, send us a message, and I'll put together some ways to get started, and also some ways to find tenants that most people don't know about that are really great. And it's very easy to do. It's low cost, and it's highly profitable, and a lot of fun too. Okay, Julie writes in, but I digress. Julie writes in and says, if the owner of a single-family residence is being foreclosed on, or has been foreclosed on, how long can they stay in after the foreclosure sale? Well, Julie, that really depends, again, on the unlawful detainer timeframes in the individual state where that property is located. What has to happen is whoever was the highest bidder at that auction, whether it was a trustee's sale or whether it was a sheriff's sale, they have to initiate an action to get that person out of the property, and that action will be an unlawful detainer. That probably deserves a little bit more explanation. Let's say it's a trustee's sale. In most states, trustee's sales do not have any equitable redemption periods. And what that means is that when the sale hits and is over with, it's final. So the very day of the sale, or a few days later, the highest bidder will be given what's called a trustee's deed, which they can then go down and record. Now the property's there, and then they're knocking on the door. So if in just days of the sale, or the day of the sale in some cases, that the person will be there talking to the people and saying, gosh, folks, I understand you've had some difficulty, or perhaps they're a renter, but I now own the property. You need to move. What can I do to help facilitate that? In a very civil but kind manner. And if they're a little bit belligerent, then of course they're going to file an unlawful detainer and get them to move. Now, we did have a situation with all the foreclosures that were going on in the country in the last few years, where some federal laws were passed that if a tenant met certain requirements, and they were paying like full market rent, and there were arm's length tenant, they weren't related to the seller being foreclosed on and whatnot, and a couple other rules, and they had been paying that rent, then it's going to be more difficult to get them out. It could take as much as 6 months, but they do need to pay the rent. If they don't pay the rent and it's a fair market rent, then of course you could still file an unlawful detainer. But if they do want to pay that rent, then you're going to have to work through that period of time. Another situation where it could delay, Julie, how quickly someone would get out is if it was a sheriff's sale, because it could be that your state is a lien theory state or a title theory state. But most states are mixed theory states, meaning that maybe in agricultural properties we're going to use the title theory issues, but in procedures. But if it was just a property in one of the bigger cities and was not used as a farm, then maybe we'll just use a lien theory. But in some states there is an equitable period of redemption. If it was a sheriff's sale in a deed of trust state, which can still happen. For example, if you were enforcing a mechanic's lien on a property, that would be done with a sheriff's sale, not a trust deed sale. So if it was a sheriff's sale, usually there's a 6-month equitable period of redemption, sometimes shorter, sometimes longer. So you're going to have to deal with that issue depending what the state is. So to answer your question, Julie, generally speaking, it could be anywhere from 2 weeks to 6 months. It really depends on the state and what the circumstances are. There are, most states have bar councils, or there's a legal bar, and you can contact the bar council in most states, and Usually they have a free lawyer night on Tuesdays or Thursdays, and you can go down there and get someone that's familiar with unlawful detainer actions, and they can go through all those rules. And then, of course, there's Googling, and Google is a great source of information on that as well. Okay, Ben writes in. He says, please explain valid, void, and voidable. Well, I don't get it. Well, I think I did that a little earlier. This question came in before the class, but once again, real quickly, valid means all of the 4 essential elements were there in complete form, and you have a valid contract. Void means there's a complete lack of one of the essential elements, complete lack of consideration, complete lack of capacity. 2 minors entering into a contract with each other would be void. And then, of course, there's voidable, where either part of one of the essential elements evaporated or it was never there to begin with, like the adult and the minor. So that's void, voidable, and whatnot. Okay. I got another question here from Andrew. Andrew writes in and says, or asks, where would I find CC&Rs? Okay, CC&Rs are conditions, covenants, and restrictions. And CC&Rs are kind of like private deed restrictions. Well, or not kind of like, they are private deed restrictions. And what happens is when a developer develops a larger piece of real estate into a subdivision, and they're the whole owner, it's pretty easy for them to vote in whatever CC&Rs they want because they own all the properties. So, and I've mentioned this in a previous class, but they put those CC&Rs in the public record. So Andrew, where you'd find those is in the public record, and title companies can pull those up for you, or you can pull them up yourself, and that would give you a list. And it's important to review those because many times they have restrictions on certain types of things. Okay. For example, they may have restrictions on street parking after a certain hour, or they may have restrictions on ham radio antennas. If you're an avid ham radio operator and you want to put up a 45-foot antenna behind your house, so you can pull in messages from all over the world, you may not be able to do that in certain subdivisions. So it's important for people to look at the CC&Rs as part of their due diligence when they're buying properties. And you didn't ask this, but moving into another element of that is in PUDs and condos and townhouses. Many times you have, in addition to CC&Rs, which are in the public record, you have bylaws. Now, where CC&Rs are in the public record, bylaws are not. And so you have to get a hold of the homeowners association and get their rules and regulations, because CC&Rs are difficult to change. Usually it's because they're single-family residences. Perhaps they could be attached housing as well. But getting everyone to come and agree on changing this or that is difficult to do. If you're in a condo or a townhouse where you have amenities that you're sharing, like a hot tub, a pool, a clubhouse, and there is a well set up homeowners association and mechanism for dispensing information out and having conversation back and forth on what we want to do with our building, then there's usually the element of the bylaws. And the bylaws could state that, the hot tub or the tennis court can only be used by residents, period. Or the hot tub cannot be used on evenings after 8:30 or 9 o'clock or something. Or they just get rid of the hot tub altogether. So it's, it can be very confining. And so not knowing, okay, let's say you have a person that does day trading, and they want to buy something downtown, but they tell you it's very important because they want redundant feeds to the internet, because if they lose their internet feed, and my goodness, they can't close their positions or trade. So many day traders have redundant feeds. They have a hardwire feed for like broadband, and then they have a satellite feed as well, because if one goes down, they have the other and can close their positions, and it's very important to them. But to do that satellite feed, they've got to have a dish. Well, some condominium associations restrict the use of dishes except for a certain area, and maybe they don't allow enough of them in that area, maybe on the roof, but you certainly couldn't put one on your balcony or whatever, so that probably is not going to be in the CC&Rs. It's probably going to be in the bylaws. And so getting copies of the bylaws on those tight-knit or types of development is very important, because that may preclude that day trader from buying in that building. And they love the building, they love the layout, they love the price, they love everything about it. But when they find out they can't do their redundant internet feeds, so they can feel comfortable doing your day trading, and it's just not going to work. Okay, that's the questions we had for this evening. I've got a little bit of time left, so I want to share a story. I mean, I get a lot of requests from people on how do I get started, and I've actually got a CD that I've given away for years. It's called The 10 Biggest Mistakes That Agents Make and How to Avoid Them. And if you'd like one of those, send us a message. You can. Would they send that to rickroller.com? Would that be okay? Or okay, go to Google Plus, and or leave a message on the YouTube channel, and we'll get one of those to you. But there are 10 mistakes you can make, and one of them that I have seen agents make is just not showing up enough. Look, if you're going to get in this business and you've got one chance to make it work, which, believe it or not, everyone has just one chance to make it work. Because if you get into real estate in 2015 and it doesn't work, and you get out, you're not going to come back and try it again in 2016. Let alone have permission to try it again by your spouse or family or whoever. It's just not going to happen. So, you've got to make this work the first time, and having it work quicker is better than having it work later, and having it work in abundance is better than having it come in real skimpy. Okay, and so one of the things you've got to do is you've got to show up. You've got to show up. Getting in the office early will be a novelty. If you show up at 7 o'clock in the office, you're probably going to be the first one there, even 7:30. Okay, and a common joke about real estate agents is, what's the first thing they do when they get up in the morning? And the answer to that joke is they go to lunch. Well, okay, a lot of us work at night because we're working with buyers and sellers, and we're doing evening appointments, and so maybe showing up at 7:30 is tough. But on the other hand, when you're first starting, you need to show up. You need to go to every sales meeting. You need to show up. You need to go to every training your broker provides. Even if, oh man, I've heard all this stuff before, you'd be surprised. You're going to pick up one or two things that you didn't catch the first time. You need to show up. You need to do open houses. You need to show up. You might want to stay late in the evening. You need to show up. Now, a lot of the firms you go to work for, they have systems for things. And they have people on call, or people that are supposed to be in the office to take calls that are coming in the evening. And so you're on call, tonight, and we close the office at 6, and then we forward the phones to you. Some of those people have things that come up. And if you're around in the late afternoon, they're always looking for someone to take their time. Some offices are not that sophisticated, or they're not that well organized, and so if the phone rings at 7:30 at night, whoever happens to be in the office could pick it up and answer it. Those are pretty good calls. Saturdays are good times to get calls as well. Now, if your office is organized and set up so that there's people on a revolving, what they call, floor schedule, then you don't want to trample on somebody else's floor time. But I'm just telling you that if you show up and you let people know that if they need someone to cover their floor time, that would be something you'd be willing to do. Okay? Why? Someone's looking for something to do in real estate, either commercial or residential. When do you think they're going to call? Well, they could call at any time. But if they have a job, they probably get off at 5 o'clock. They've got to do something, and it's, the summer hours are still lighted. The sun stays up until 7, 8, 9 o'clock. If you're in North Dakota, 10:30. So they're cruising around looking at things, and if they see a sign, they may call the office. Now, there's a key there as well. If it's okay with your broker, I put my cell phone on the sign because I want the calls going straight to me. Now, some brokers prohibit that and say, no, you could put your cell phone on a rider, but I want the office number on a sign. And there's good reasons for that as well. I mean, it all depends on your broker's policy. But if you have a situation where potential buyers are calling the office, then it would behoove you to be in the office when those calls might come in. Now, chances are they may call the rider on the sign, the extra hanging below sign that says, hey, this is my listing, call me. And they may have tried that number and they got no answer. And so they call the office number, and then you're there and you pick up the phone. Well, I was working late one evening, and I got a call. And the gentleman called in and he asked about a very expensive home. It was in our inventory, and I hadn't even, this is my like the second, third week on the job, and I hadn't even looked at that house yet. I'd looked at some of the less expensive ones, but I hadn't looked at that one. So I hadn't previewed it yet. So when he called in, I really couldn't answer a lot of his questions, but he was very patient with me. But I did know that was a very exquisite, expensive home, and that maybe I ought to do some pre-qualification on this guy. And so I asked him, well, I need to ask you a few questions. What's the range of the home that you live in now, and have you talked to a lender about buying this one? He says, look, kid, because I was a kid. He said, I appreciate you wanting to pre-qualify me, but my name is Al Partee. Just ask around, and I'm not going to get a loan. I'm going to pay cash. I said, fine. Thank you. So the next morning, when I went to the office early, and I was there doing things, and the secretary came in, our office administrator came in, and she, I asked her, have you ever heard of a guy named Al Partee? He says, oh yeah, Al Partee. He's a very wealthy individual. How do you know him? Well, he called in last night. He wants to look at this house. Well, yeah, he can buy anything he wants. So I called Mr. Partee up. I went out and picked him up to show him the home, and he bought that house. I mean, it was a long, convoluted negotiation. It was one of the most difficult negotiations I've ever done, because Al would make an offer, and the owner of the property was a gentleman named Jim, and Jim would counter the offer. And then Al would counter the counter, and then Jim would counter Al's counter, and it went back and forth over like a week and a half, and it was very excruciating to me, because it was on again, off again, on again, off again. But being a young age, and I really didn't know that, I didn't read people as well as I can read them today, and that's exciting, because the realtor you will become is better than the realtor that started. Okay, you're going to develop things, but you can still make a living, and a dang good one, learning, and you can earn while you learn. I mean, that's a great opportunity in real estate, and what you're earning is probably much better than you could get in any job anywhere. But these guys were kind of messing with each other. I mean, I found out later that they actually had some business relationships that had not been all that satisfactory to either one of them. And so, they knew each other, and there was some animosity there. And maybe that's one of the reasons why they were, throwing things back and forth. I don't know. But I dropped by Al's house one night, and he was all dressed up, which was unusual for him, because he was really, the definition of dressing casual. And in fact, the first time I went to pick him up, to go show him this exquisite house, there was a gentleman out in front of this equally exquisite house working in the rose garden, and I thought he was a gardener. And I pulled up in the driveway, and I said, I'm here to meet Mr. Partee. Or should I just go knock on the door or what? And he says, well, I'm partee. And he got up and he had, he brushed off his hands and he had like his jeans that he was wearing had rips and tears in them. And he says, well, I'm ready to go. Are you? So we went to look at this house. And anyway, that was Al. But this particular night I dropped by with yet another counter from the seller. And Al was all dressed up to go out on the town. Man, he was looking good. And I said, wow, I'm sorry, did I intrude? Is this, well, tonight is my wife's birthday. This is really fantastic, and she was still getting ready. He says, that's fine, Rick. She'll be another half an hour before she's ready to go. And we have reservations, so we're fine. And so what have you got? You got another counter? Yeah. And he looked it over and he set it down on his desk. We're in his home office. And he said, hey, let me show you something. And he reached in his suit pocket and he pulled out this jewelry box and he popped it open. And in it was the most exquisite diamond necklace I've ever seen. And he said, this is what I bought my wife for her birthday. Do you think she'll be excited about it? I looked at it and says, Al, that's exquisite. It's phenomenal. Most women would just be thrilled to death. What do you think? Do you think she'll like it? Oh, yeah, she'll like this. And he looked at it, closed it up, put it back in his pocket. And I said, Al, I can think of something else she'd like. He said, well, what would that be, Rick? Well, I know she wants that house. And he kicked back in his chair and he said, you're right. I'm going to sign this counter proposal. And he signed it. And then his parting words were, now you get together with Jim and you straighten out this whole mess and you rewrite this thing, because there's been so many counters and counters to the counter and everything else. I really don't even know what the deal is. So straighten it all out and write it down in simple fashion, and then I'll sign that one too. And we've messed around with this long enough. And so that night, he was able to take her out and give her that exquisite necklace, and I'm sure she just flipped over. But he put the real capper on it when he said, and by the way, I bought you that house too. And that was a cool experience. And I got to think, where did it come from? Because a lot of the agents in the office, when they found out I was working with Al, they said, how did you pick up that lead? It's fun. You know what happened? I picked it up because I showed up. And that was one of the biggest sales in a single-family residence in the board that year. And that went to a rookie because he showed up. And also because I played the game that he and the seller were playing back and forth and ran back and forth. But I also was intuitive enough to close when he wanted to buy. Now, if that was just an isolated story, that would be kind of fun, but it wouldn't really prove my point. So I want to mention that on another Saturday when look, I worked in a smaller office. There were, I think I was the 10th agent in, and when I was there, I think we grew to like 13 agents, and most of these guys were very well experienced. There were just 2 or 3 of us that were new babies. These guys had great books of business, and they didn't work a lot of Saturdays, but I did because I needed to. I didn't have this big book of business, so I was there a lot on Saturdays. People would walk in. We had walk-ins. So one Saturday I was there, and this gentleman walked in. And he had on a Vietnam-era green fatigue jacket and Vietnam-era boots and jeans, a big beard, and some pretty long hair. And I thought, well, okay, I don't know. And he says, look, I'm coming in because I want to get some information on that commercial piece of property you've got out by the airport. I said, okay, I can find that information for you. I'm not, well versed on it individually, but I can certainly pull that together. Well, that's okay. I want you to pull it together for me and get it over to me, and because I have a friend that's flying in next Thursday, and I think he would like to buy it. I says, okay, great. So I rummaged around the office, found a fact sheet somewhere, and gave that to him and said, I'll pull some more information together. This was a Saturday, remember, and this other person is flying in on Thursday. And he didn't tell me who it was. He wouldn't tell me who it was. But he did give me his information. And so I pulled more information together, including plat maps and a few other things, and got it to him. I actually hand-delivered it to him, and he says, okay. When I hand-delivered it to him and showed that, I was earnest enough and forthright enough and motivated enough to pull together a more complete package for him, he told me that his friend's name was Dan Hopper and that Dan was flying in his own Beechcraft aircraft. So Thursday came along, and I agreed to meet this gentleman and Dan at the property. So he went to the airport, picked Dan up from his airplane, and then he came to the property, and we walked the property, and we talked about it, and Dan was very interested. And from that moment on, my communication was with Dan, not the first gentleman. And what they had worked out was some sort of participation for this other guy because he found it and Dan wanted it. And so Dan was a syndicator out of California. And he had made a lot of money in California, millions of dollars, syndicating properties and putting together limited partnerships that would buy them with wealthy individuals. And he had a long stream of people that were anxious to do business with him because they always made money. And Dan had a real skill and knack for it. And he liked this property, and we put it under contract. Coincidentally, the property is actually owned by my broker. And we put it under contract for about $1.07 a foot back in those days. And by the way, that was a tough one too. I mean, because Dan wanted to pay $1.05, and my broker wanted $1.10. And they were dickering back and forth, and I finally just couldn't take it anymore. And I got Dan on the phone. I said, Dan, look, I know this is presumptuous, but look, he said $1.07. It's only 2 cents off per square foot. You're just being pig-headed. Sign the dang thing. And he said, yeah, Roller, you're right. I'll sign it. And he signed it. And that was the start of a great relationship with Dan. And he bought that property. He bought several others. We later were able to turn that property that he bought for $1.07 for, I think it was like $2.50 a square foot. And we sold it to a large hotel chain. We turned several other properties. I found a number of properties for him to buy, and we made really good money working with Dan. And he was a pleasure. I found I had some inside information about a mall coming to town, and so I got him into 10 acres, or was it 40? It was 40 acres at $10,000 an acre. And then later we sold it in several dollars a square foot. Now that's serious money. After that transaction, there was a few times Dan would show up in his car, which was a real nice little Mercedes coupe. And I used to remark, to him on how fun it was and what a nice car it was. Well, we did all those deals. There were, probably about a dozen different deals we did. And Dan made a lot of money for his investors. I made a ton of money on commissions. And one day Dan showed up. Now, this is after I had left my broker and started my own brokerage company. And, during this period of working with Dan, I'd actually transitioned to my own company. And anyway, Dan showed up one day, and he walked in, and he handed me the title to his little Mercedes. I mean, that was a nice bonus. And also my first Mercedes. But where'd all that come from? It came from showing up. Now, I don't tell war stories to tell war stories. A lot of trainers may, and that's fine. The reason I told you these two stories is because I want you to know the power of showing up. I want you to feel it. I want to make it real to you. because that the stuff I'd done on the big stuff was, on the single family residence was great, and the stuff I did with Dan was great too, because that contributed, at least on the first transactions, to me making Rookie of the Year. But in my second year of real estate, folks, I sold almost 100 houses. It was like, in the 90s, back in those days, that was unheard of, and it was all due to working real hard, but showing up. So I would admonish you, if you want to make this work, please show up. Go to all the training classes you can go to. I mean, there are some that you can go to for free. There's some you're going to have to pay for. But that's okay. You need to invest in yourself and show up. You need to get every book on real estate from the library and read them all. And I'm not talking about you can get some of the get-rich-quick books in real estate, because you'll be dealing with buyers and you need to understand some of the techniques. But I'm talking about the serious real estate books, the ones that teach you how to list and sell. There's a lot of them, and you could check out Amazon, and you can check out stuff online, and I've got some programs that I'm very proud of that have helped me develop not just Rookie of the Year for myself, but for 8 other agents. And I would be very pleased and would admonish you to take a look at buying those as well. But please, if you're going to make this business work, you got to show up. And I beat it to death, but it's from my heart. Because I see too many agents that, they come in the first week or so, they're so disorganized. They ordered their cards. They did all this other flu stuff that they should have done way back, even before they got licensed. There's things you can do before you get licensed to get ready, so that day one you hit the bricks running. And that's important too. But you've got to show up. Do not let things get in the way. There's one danger, and I mentioned this in the 10 biggest mistakes that agents make, and that is you've got to understand how valuable your time is, and you've got to organize your time, and you've got to use your time. And what will happen, and you will see this happen, is particularly if you have a family and you have responsibilities and you have a spouse and they're working also, and because you don't have a real job, you'll be the one relegated. Can you get the oil change? Can you pick up the dry cleaning? Can you take kids here, there, and everywhere? And if it interferes with your work time, you can't do it, because you have a real job too. And you need to show up. And one missed opportunity could be the difference between meeting your high-end buyer or meeting your syndicator. Because these are not just my stories. They will be your stories if you show up. Well, I'm Rick Roller, and that's, from my heart, folks. That's as sincere as I can make it. This is a fabulous business. This is a business that can change your life. This is a business that is like no other. This is a business where you could control, through listing, millions of dollars worth of real estate with a little shoe letter and a little chutzpah, a little nerve, you can go out and list properties that will, by contract, say that when that sells for the period of time you have it listed, you'll make a 3% commission, or your portion of it, after you pay your broker. But think about that. People invest millions or hundreds of thousands of dollars to get into a business so they can make this profit. But in real estate, you could literally control. I used to live across the street from a Chrysler dealer. He was a wonderful guy. His name was Miller. But unfortunately, he bought the Chrysler dealership in the days. Well, it was pre-Iacocca, okay. And Chrysler had all these big old boats in their showroom, and nobody wanted to buy them. And it was pretty dark days, until Mr. Lee Iacocca came along and turned Chrysler around. But he was such a wonderful neighbor and such a wonderful man. In fact, I bought 2 cars from him. you know, but I would go into his dealership, and I would walk in there, and I and I would call his name, and it would echo through the dealership. Hey, hello, 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 hello. It's Rick. I'm here to take you to lunch. I'm buying. So he'd come out, and we'd go to lunch. And I said, man, you got a lot of inventory sitting on your lot. And he says, yeah, I do. And he says, how much? It was millions of dollars. And I said, so what's your floor plan? I mean, what's your float? And he said, well, I'm paying 2 points over prime, and prime is pretty high. And I whipped out my calculator, and I'm figuring out, what his daily interest cost was on the inventory sitting on his lot. And it was a lot of money. And he said, don't tell me, Rick. Don't even tell me. You ruined my lunch. Okay. And I left. Well, I picked up lunch, and I took him back, and I left. And I got to thinking, driving back to the office, that he had like $3 million in inventory, and I had over $3 million in real estate inventory. And what was my carrying cost on my inventory? Well, let me see, sign maintenance, because occasionally someone would steal a sign. Okay, let me see, board dues, add board dues. And I did some advertising, but, my maintenance was, my expense, my carrying cost of carrying $3 million in inventory plus was minuscule compared to his business. What an opportunity you have in this business. It is phenomenal. It's like no other. But you got to show up. Well, that's Rick Roller. That's tonight's Google Hangout. I hope you enjoyed the information and the pep talk. Hey, send in your questions if they're on any topic in regards to the exam. Happy to approach those. And if you have some real-life questions, I can try to work a few of those in as well. But until then, we'll see you out there. And remember, it's all about blessing lives and making money. If you bless the lives, you deserve the money, and the money will come. But concentrate on blessing lives, and you'll make money. This is Rick Roller, and we're signing off for now.